cards because I switched bags.
Oh, the famous woman, my
Yeah.
husband says to me, what do you mean? I go, no, I changed my package. What does that mean? I'm like, you don't get it.
Yeah, let's see. I might have one stuck.
Well, I have your stuff from the
Yeah,
presentation,
perfect.
so I'll have Loretta, my office
Wonderful.
assistant.
Yeah, I know there's a way, but I don't know how. I've always went, oh, there's a little lever. This might be the lowest that it goes. Yeah, it's the lowest.
That's the lowest that it goes. Who would ever want to sit up that high?
Somebody who's really short.
So I had sent them a PowerPoint. Do you know if they're gonna put that?
I would ask Cindy.
When I said I have it on a flash drive. Yeah.
They have the projector, so I'm sure they're gonna
Yeah.
put up. But I would ask Cindy.
Go ask her.
We're gonna start in about 5 minutes, I guess.
Okay.
Yeah,
I'm running to the ladies' room.
sure.
Are you doing PowerPoint?
No.
You know, the last time I felt like it was hard to see, and I didn't know if this would be a tougher crowd. You
It,
know,
it probably is.
that was my thought.
We're gonna start in about 5 minutes, everybody. Let people come in and get coffee and get settled in.
If not, I can talk after.
See what happens.
So I have to take everything off the flash drive because I can't fuss with stuff.
Okay, and there you have it. Now I'm probably gonna have to just make it full screen.
Do it. I don't know how to get rid of.
So,
Okay, so I'm good. I can.
yes, for now, you don't have PowerPoint, do you? So for now, we'll
No, I'll take my.
leave the lights the way they are, but we may have to dim them. I'll go in the back and see how this looks.
Okay, so, well, I wanted
think
to
it
take.
should- That's okay.
No,
should
well,
be
other people are
fine.
gonna be speaking, so I could just, let me just exit out. We know it works, and now I know how to do it. Okay.
Okay.
And if Jamie has, I think she said she brought,
So if we need to dim the lights, I'll have somebody do that. I think there's something here, this gadget. Okay.
Puts it
For a
up.
child.
Yeah.
I think you have to sit on it to get it in. Great. Well, we have plenty of change.
that's all right, we're not gonna worry about it.
I don't even know that I could get my body out of bed. Switch it out.
The,
Oh,
you
God.
have one?
No, you know what I didn't do on this time? I thought about it and I did it last time and I wasn't sure. Okay. I wanted to. Thank you. Okay.
All right, so we'll get started in a moment.
I get 1 cup of coffee a day. My interest will be 7.
Shall we? Yeah? Yeah? All right, everybody, we are going to get started. There's probably people getting coffee and bagels and trickling in. You can just come in at your own pace and have a seat once you do. So, my name is Mark Friedman. I practice getting this microphone a little bit higher. I practice trust and estates and elder law in Bridgewater, New Jersey, about 20 minutes up the road from here. I'm an attorney at Friedman Law, where I practice alongside my father, Larry Friedman. And I'm here with my colleagues, Jamie Berger and Christine Ann Soto. Jamie is a family law attorney. She practices family law and matrimonial law at the firm Jacobsberger?
Yes,
Jacobsberger in Morristown, New Jersey. And Christine is a special education and guardianship attorney and practices that out of her offices in Hudson County and Bergen County. So, I'm going to be talking. So, the way we kind of envision this program is that it's kind of a grab bag of different topics that we think would be relevant to seniors, that we think would be useful, that we think would be informative, etc. So we're covering a bunch of different stuff at kind of a bird's eye overview. So I'm going to be talking about the basics of elder law and estate planning and trust and estates. Jamie is going to talk about family law, matrimonial law, stuff involving grandchildren. And Christine is going to talk about education law and guardianship, schools, things of that nature. So without further ado, I'm going to get started. I'm going to talk about estate planning. And towards that end, I would like to relate a story to all of you. On February 25th, 1990, a young woman woke up in the middle of the night and walked down her hallway. She may have been going to the bathroom or kitchen to get a glass of water or something, but she never made it there. She collapsed in the middle of the hallway. The noise woke up her husband, and he got up and called 911. And an ambulance came out and picked her up and brought her to the hospital and rushed her to the hospital. And the doctors there determined that she had gone into cardiac arrest, which means that her heart stopped. They saved her life. They resuscitated her, but they did not revive her. They weren't able to wake her up. She remained unconscious. So they put her on a feeding tube and a ventilator, which is a machine that breathes for you. And they waited for her to wake up. But she never did. She remained unconscious. And after several months, her doctors determined that she was in what they called a persistent vegetative state, that they expected her to be permanently unconscious and that she would not wake up. And what followed next attracted national media attention. You might remember this case. The young woman was named Terri Schiavo, and between the late 1990s and 2005, her family waged a bitter legal battle over what should happen to her. Her parents felt that Ms. Schiavo should be kept alive as long as medically possible. They felt that, as long as it's possible to do so, she should be kept alive. Her husband argued that in that state, she would not have wanted to be kept alive artificially, and she would want to let nature take its course. Ultimately, the case involved years of court hearings. It went to the Supreme Court 4 times, and it involved the intervention of the United States Congress and President George W. Bush, and Florida Governor Jeb Bush, who you might remember from the last election. It was just a firestorm. It was a knockdown, drag-out legal battle. And you can imagine the kind of emotional toll that this took on Ms. Schiavo's family, pitting her husband against her parents in such a public way. And also the financial toll that it took on her family. If you've ever done anything with a lawyer, you can imagine how much it would cost to go to the Supreme Court 4 times. And the fight at its core boiled down to what would be Ms. Schiavo's wishes. So, I think that there's an extra layer of tragedy to this story because there's the medical tragedy. It's this young woman who was in the prime of her life, who collapsed and never woke up. And that's terrible, but that's out of our control. That's not in our hands. We can't control our health. But the fight, really, between her family, it boiled down to what would she have wanted? What are her wishes? And that's something that all of us can control. We all can say what our wishes are. And if Ms. Shivo had expressed those wishes in advance by writing them down, her family would have known what she wanted, and they wouldn't have any grounds to make that fight. And fortunately, that's something that everybody who's in this room is able to do, to express your wishes in advance, so that if in the future you can't express them, you can't make decisions, you can't express them, your loved ones will know what you would have wanted, and that is the essence of estate planning. A lot of people think of estate planning as this macabre thing. It involves facing your own mortality and things of that nature, but I view it as an opportunity, and it's an opportunity to set forth your wishes now so that if in the future you've passed away or you can't make decisions or you can't express your wishes, the people around you know what you want and they have to follow them because you're doing it in a way that's legally binding. So I think it's a great thing. I think it's an opportunity, and I know that everybody should have an estate plan. It doesn't matter who you are, you should have an estate plan. There's 3 basic components of an estate plan that everybody should have: a will, a power of attorney, and a healthcare directive. Some people should have other stuff too, but those are the basics that everybody should have. Those are the basic 3 documents that everybody should have. I'll start by describing a will because that's the one that people are most familiar with. Oh, and by the way, if folks have questions, please go ahead and raise your hand. There's microphones set up. You can use them if you want, but you're also free to just blurt out your question across the room if you have a loud voice. We'll repeat it to the microphone. We want people to walk away for this presentation with useful information in hand. So if you have any questions, please go ahead and raise your hand. Don't be shy. So a will is a document in which you set forth instructions regarding your property and legal rights after you pass away. You make it while you're alive, of course. And in it, you tell the world how your property should be distributed after you pass away and who should assume certain legal rights that you had while you were alive. So your will can do a number of different things. You could set forth how your property should go as well as a backup plan for that property. So the classic example is I leave everything to my spouse, to my wife or husband, but if he or she passes away before me, then to my children in equal shares. And if any of my children pass away before me, then to their children. But if they don't have children, then their share gets divided between the remaining children or grandchildren, in what proportion, et cetera, et cetera. So it can get a little bit complicated. You can address that with language, but you need to know what you're doing in order to do that. You also can appoint an executor, which is a person who manages your estate after you die, but before it gets distributed. And this person deals with things like filing any estate or inheritance tax returns, paying any taxes, reducing your tax liability if there's a way to do so, resolving any creditor claims if anybody says that you owe them a debt, selling your house if nobody wants to live there, marshaling all the different property into an estate account and making sure it gets paid out, et cetera. So it's important to appoint somebody who's trustworthy as executor and who you think is competent, who you think is going to be able to get all this stuff done. If you have children who are under 18, or you serve as guardian for a minor or an incapacitated person, Christine's going to talk about this more later, but you can appoint somebody to take over as guardian in your will. You can appoint somebody as testamentary guardian to take over after you pass away, after you're no longer able to do it. Your will can also help reduce or avoid potential estate or inheritance taxes. I don't really have time to go into that in detail, but essentially, everybody pays income taxes. Every year you file your income taxes. When you pass away, the government isn't done yet. They apply certain taxes to your estate and inheritance taxes. Not everybody has to pay them, but if you do, your will can potentially include some stuff that reduces your tax liability. And your will can include trusts if appropriate. So a trust is essentially a legal arrangement where assets are set aside to benefit from somebody, but they're controlled by somebody else who's a trustee. So if Jamie was my daughter and 12 years old, and I have an estate, let's say $500,000, I pass away. I want it to benefit Jamie, but I don't want a 12-year-old kid to be able to manage $500,000, or even an 18-year-old kid to be able to manage that much money. They're gonna go and buy a Lamborghini or something stupid, and it's gonna ruin this thing that could have been used to provide for their future. So I'm gonna put my sister, Christine, not actually my sister, but for this, to manage the trust. She's gonna be the trustee of the trust. She can only spend the money on Jamie because that's what I put in the terms of the trust agreement. But she controls the money, she controls how it gets invested, she controls what it could be spent on, she decides when to spend it, how much to spend, etc. So that's the essence of a trust. So situations where you might want to trust. If you want to leave an inheritance to somebody who's too young or immature to wisely manage the money, somebody who has a drug problem or a gambling problem and the money might get them into trouble or they might waste the money, somebody who is going through a divorce, or who's getting sued, who's the subject of a lawsuit, or somebody who has serious debts and creditors might just take the money away from them. Somebody who has serious disabilities and inheriting a bunch of money might make them lose Medicaid or disability benefits. Those are all situations. Also, sometimes if somebody's in a second marriage, people want to leave their estate in trust to their spouse for the spouse's life, to provide for the spouse. And then when their spouse passes away, the balance goes to their children for a prior marriage. Those are all situations where it may be appropriate for you to have a trust as part of your will or as part of your estate plan. Some lawyers think that everybody should have a trust as part of their estate plan. Everybody should have a revocable living trust. You might have heard about this. Some people push the idea, but I don't think that everybody should have a trust. I think that in some situations you have to have a trust. In some situations it's necessary to have a trust. But for a lot of people, I think that a will alone is sufficient. I think that you don't need a trust in a lot of cases. So the will, it's a legal document that sets forth your wishes after you pass away. The next two documents, a healthcare directive and power of attorney, are for while you're alive. So the second document that everybody should have is an advance directive for healthcare. I'm going to call it a healthcare directive because advanced directive for healthcare is kind of a mouthful. With a healthcare directive, you set forth your wishes regarding medical care, and it takes effect if you're alive. So it's not like the will, you're alive, but you've lost the mental capacity to make decisions or express your wishes. So Terri Schiavo, when she was unconscious, she lost capacity to express her wishes. If somebody has a serious stroke, or they have advanced dementia or advanced Alzheimer's disease, they may not have the ability to make decisions for themselves. That's a situation where a healthcare directive would take effect. So a healthcare directive has two parts, an instruction directive and a proxy directive. An instruction directive is also called a living will. In it, you set forth your wishes regarding medical care, especially end-of-life care. The classic example is the one that I discussed earlier, where somebody's unconscious, they're being kept alive artificially. Do they want life support kept in, or do they want to let nature take its course? But you can also put other stuff in there, instructions regarding painkillers. If you have any religious preferences, those can be in there, etc. So that's the instruction directive. It's also called a living will. And the other part of a healthcare directive is a proxy directive. It's also called a medical power of attorney, and in the proxy directive, you can appoint somebody as your healthcare representative, as your agent, to make healthcare decisions for you if you're not able to make them. So to consent for surgery, for example, if you don't have an emergency situation, you have to have consent in order to perform surgery. So you can appoint your healthcare representative to consent to surgery for you. And it's important, if you appoint somebody, and it's a good idea too if you have somebody who you can appoint, it's important that you have a discussion with that person about your wishes. It's important that you make sure they know what you want, especially in sensitive medical situations. There's something else that's pretty important, which is being able to waive your patient privacy rights with a proxy directive. So there's a law called HIPAA. I forget what it stands for, but it says that generally healthcare providers during the relevant part, Health Insurance Portability and Accountability Act, is that? Anyway, so HIPAA, it says that healthcare providers should not disclose private patient information. There's a lot of discretion there, but it means that sometimes doctors and other healthcare providers refuse to share information with loved ones. We've had cases where hospital staff refused to even confirm what hospital a patient was in to somebody's child. And you can imagine the kind of stress that that caused to that person not being able to know, where their parent, what hospital their parent was at. Yeah. Yeah. Mm-hmm. Yep. Mm-hmm. 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 So the way the patient, so the question is, I think I understand the question to be, can patients' family members give information to doctors in light of the patient privacy rule? Okay, so right. So the way the patient privacy rule works, it's a one-way wall. So it says that doctors can't disclose private information to people other than the patient or certain health insurers or other people. They have discretion to make exceptions to that, but generally they're not supposed to. You, as the patient's family member, can provide information to the doctors, but they might not know to call you and solicit that information from you. So if your mother had appointed you as her healthcare representative, for example, under a healthcare directive, I can't say that they definitely would have called you, but I think they're more likely to call you. Unfortunately, the way our healthcare system works, sometimes everybody doesn't talk to each other. They probably should, but they don't. But if you appoint somebody as your healthcare representative, healthcare providers are more likely to involve you in that decision making and get that information from you. I'm very sorry to hear that. The HIPAA, it can be very important to give people the right to waive your patient privacy rights so that the information could be shared with you. Yeah, we had a question over here.
Yes, very hard of hearing, and if people could just talk a little slower or use the microphone when they have a question. I don't even know what the question was.
Oh, it was about how information could be shared between providers and patients and their families. Yeah, I'm just concerned that if we have people using the microphone, we're not going to be able to get through all the questions and materials that we need to. But if somebody wants to use the microphone, they're certainly welcome to do so. And we'll try to repeat the questions as we get them. Yeah.
My question regards.
This is good. Project your voice. Big, booming voice. Perfect. And a big heart.
My husband passed away November,
Yeah.
just over 6 months. And I've done everything you said. I'm prepared in that aspect. My question is, when is it a good time to put my children's name on the deed to my house so Medicare doesn't take over on that when if anything, have to go into the nursing home?
So we're going to talk about that later. I'm going to tell you exactly my thoughts on that in the second part of this presentation. So the third component of an estate plan that I think that everybody should have, I just got to get through this material. So the third component of estate plan that I think everybody should have is power of attorney. This is a document where you can appoint somebody to manage your financial affairs. You can have this take effect immediately, or you can have it take effect only if you lose capacity. It's up to you. You have a lot of control over this. And you can give your power of attorney agent as much or as little authority as you want. And we find that most people give their agents broad powers because they want them to be able to manage their affairs if they're not able to, including the power to write checks, to open and close bank accounts, to manage investments, to enter into contracts, to buy or sell property, etc. One thing to note is that in New Jersey, your power of attorney agent does not have the ability to make gifts unless the document explicitly says so. There's a law in New Jersey that says that you have to explicitly say my power of attorney agent can make gifts, something to that effect, in order for your power of attorney agent to be able to do so. If you don't want them to be able to make gifts, that's great. But for long-term care planning, which I'm going to talk about next, it can be necessary to make gifts. So if you have a basic power of attorney that's downloaded from the internet, or that's drafted by an attorney who isn't that familiar with long-term care and elder law, it might not be sufficient for elder law purposes. Your power of attorney agent is a fiduciary, which means that they have to act in your best interest or else you can sue them. But that really doesn't do you that much good if your power of attorney agent steals all your money and runs away to the Bahamas or some other country with no extradition treaty. So it's important that you appoint somebody you trust to that position. A lot of times, almost all the time, people appoint their spouse or their children. It's important to appoint somebody you trust as your power of attorney agent. These two documents, the Power of Attorney and Healthcare Directive, allow somebody to manage your affairs if you lose capacity and you're not able to do it yourself. That's important because later in life, some people lose their capacity due to a stroke or a progressive disease like dementia or Alzheimer's. And if that happens and you don't have a power of attorney agent and a healthcare representative in place, then there may be no way for you to pay your bills or take steps to protect your property or manage your healthcare unless somebody goes to court and applies for guardianship. And Christine's going to talk about this in more detail, but the bottom line is that it's a lot easier to just get these documents drafted and sign them. It's easier, it's cheaper, and you have more control over the process rather than going to court and getting a court. What's that? Oh, okay. Let's see. I want to see if I can make this microphone higher. Son of a gun. Well, that didn't work. I can't. This is as low as it goes. I could crouch. Let's see. Is this a little bit better? All right. I will hunch over. That's how much I care about getting the information to you folks. And if you can't hear me in the back, just go ahead and let me know. Yeah. Good. I apologize for that, but unfortunately we have a lot of information that we need to cover. All right, that's fine. I just want to make sure that I get you all the information that I think you need to know. Yeah. I don't have slides in mine. There's an outline. Do you guys have the materials up here?
That's my presentation with the slides.
Yeah.
So in the red book, there should be written material that corresponds with particular sections. So, and there's sorry, nobody can probably hear me, but there's a table of contents in the front, so it should be somewhat easy to follow along.
Yeah, let's see. Did they put my materials in here? I hope they put my materials in here. Let's see. I'll tell you exactly what page we're on, hopefully.
Does anyone need a
Maybe
red
not.
book? I think they're out front.
You know
Wait.
what, I'll get a stack. Here, I'll
Actually, I don't think this is 79? 17. All right, page 17 on the outline, not the red book, the outline. Right? There's a separate outline. It says Freeman Law at the top. The lady in teal is holding it up for everybody to see. Yeah, it's in the middle, page 17. Thank you for pointing that out. That's really helpful. All right. Anyway, so as I was saying earlier, if you don't have these estate planning documents in place and you lose capacity because of a stroke or dementia or Alzheimer's, at that point it's too late to do these documents. It's too late to sign these documents and get them in place. And you might have to go for guardianship. So if there are any concerns about health or declining mental capacity or anything like that, it's important to get the documents done sooner rather than later. And, it's an opportunity that I think that everybody should take advantage of. And if you're interested in that, you should talk to an attorney about creating an estate plan. I'd be happy to talk to you. That's why I'm here today. But it's important for everybody to do these documents, but especially if there's any concerns about declining health. All right. So that's the estate planning section. We're going to talk about elder law now. And it looks like we got an influx of new people. Welcome, everybody. So elder law involves helping older Americans deal with a variety of legal issues that come up, but most of the time when people talk about elder law, they're talking about long-term care planning. So a lot of folks, as they get older, are no longer able to do all the things for themselves that they used to do. Some of these folks eventually need long-term care, which is different from acute medical care that's designed to treat a specific illness or condition, surgery, medicine, things of that nature. Long-term care is where somebody is helping with basic daily living activities, helping you get around, helping you get dressed, helping you get bathed, things of that nature. Basic things that you need to do in order to live your life. That's what long-term care is. Long-term care happens in a variety of settings. It happens in the home with family members or paid caregivers or home health aides providing care. Or more intensive long-term care could be provided in a facility setting, such as a nursing home or assisted living facility. From a legal and financial perspective, so not a medical or psychological perspective, we don't solve that problem. Perfect. That's the solution that we need. All right, can everybody hear me better now? In the back? Yeah? Okay, good. All right. Anyway, so from a legal and financial perspective, the problem, which is the only thing that I as a lawyer can help you with, the problem with long-term care is that it is incredibly expensive. Home health aides typically cost about $22 an hour. If somebody needs help several hours a day, every single day, it adds up really fast. Assisted living facilities usually cost about $8,000 a month or more in New Jersey. And nursing homes in New Jersey, in North Jersey especially, a lot of times cost $11,000 or $12,000 a month. So, for somebody who needs that every single month for years on end, it can add up to hundreds of thousands of dollars very quickly. So even if you have significant assets, and even if you've been saving up your whole life and you've built up a significant nest egg, long-term care costs can quickly wipe out your estate, leaving your spouse impoverished and your heirs bereft. The goal of elder law and long-term care planning is that when you're faced with these enormous long-term care costs, we help you save as much of your assets as possible within your family. So instead of spending everything on a nursing home within a couple of years, we try to preserve your assets for your spouse or your kids or whoever you want to benefit. And the way we do that is by helping you qualify for Medicaid. Medicaid is a joint federal and state program that pays for health care. It's different from Medicare. Medicare is a health insurance program. Medicaid is also a health insurance program, but only Medicaid pays for nursing homes and long-term care. Medicare does not. So Medicaid will pay your costs in a nursing home, assisted living facility, or to some degree for aides who provide care to you in your home. But to get it, you have to qualify for Medicaid, and there are very strict requirements to qualify for Medicaid. There's medical requirements, which I won't go into in depth here, and there's financial requirements as well. So for financial requirements, the Medicaid agency looks at your income and assets. So they figure out what your income is every month and your assets. You have to have income within certain limits, and your assets, you have to have less than $2,000 in assets. There's a bunch of caveats to that. Your spouse can keep a certain percentage of your assets, and you can have a home that you or your spouse or certain other people live in, or certain other assets. But generally, $2,000 is a very strict, hard and fast limit. And it's a very low limit. So for people who are lucky enough to have savings or assets, qualifying for Medicaid and getting your assets below $2,000 is going to involve spending them down. You might think that a way around this is to just give all your money away, or put your house in your kid's name. There's a lot of advice floating around out there about that. There's a lot of stuff on the internet, but I really don't want you to walk away from this presentation with that idea in mind, because it's a really bad idea doing that without guidance from an elder law attorney. Yeah.
I just wanted to say, I just went through this whole process.
Mm-hmm.
And I do have power of attorney that you need. You have to carry it around with you all the time because people continually ask for it. But Medicaid, you have to have like 5 years.
Yeah.
My mother threw everything out of her house. I went over there and the bank wants to charge me for them. And you have to have 6 months and then the previous 54 months.
Right.
A statement for every quarter.
Well, it depends on the county. Some statements make you provide a statement for every month. We're just talking shop right now about the process for applying for Medicaid. We'll cover that in the presentation. So anyway, Sorry? Yeah, we'll talk about this as part of the presentation. So, you know, the thing to know is that it's a really bad idea to just try to put your house in your kid's name or give all your money away without guidance from an elder law attorney. You should see an attorney who knows this stuff well before you do anything drastic like that. Because Medicaid has a 5-year look-back period. They review your finances for the past 5 years. When you apply for Medicaid, you submit 5 years worth of records for every account that you had, whether it's open or closed right now. It's a giant mountain of paper, and you have to track that down. And the Medicaid worker and your attorney, if they're doing it right, actually goes through that mountain of paperwork and looks at every page. And what they try to determine is whether you've made any gifts in the past 5 years. And if you have made any gifts in the past 5 years, they impose a penalty. And the penalty is that Medicaid will not pay for your long-term care for a certain time period. They won't pay for your nursing home or health aides or assisted living facility for a certain time period. Currently, in 2017, you lose about 1 month of Medicaid for every $12,000 that you give away. So in the last 5 years, if you gave $36,000 in wedding presents, or you bought somebody a car, or you paid for somebody's college tuition, and your Medicaid would have started July 1st because it's $36,000, they impose a 3-month penalty. So instead, it now is going to start October 1st, and you are going to be left to cover that 3-month gap. But at this point, you've already spent your assets down below $2,000. The penalty period doesn't start until you've already spent down below $2,000. So now you've got this big nursing home bill and no money to pay it. And you can get yourself in a lot of trouble that way. If you give away your house, and your house is worth $350,000, instead of 3 months, you're going to get a 2.5-year penalty. And you're going to have to pay for 2.5 years with no money and no way to do that. And if you give it away to your kids, for example, if they give the whole thing back to you, you can get out of the penalty, but they have no obligation to do so. And maybe something has happened to them in the meantime, and they can't give it back to you. There's a divorce, and the asset and the house had to be sold and split up, or whatever.
That's my question. So if the person did only have less than $2,000 in assets at the time, then they don't penalize the person, like each one in?
No. So the question is, if somebody has $2,000 in assets, they don't penalize them. So $2,000 is the admission price to the dance. Once you get in, they look at your 5 years of statements and they penalize you. So you have to have $2,000 for them to penalize you. Otherwise, they won't even look at your application. And they'll impose a penalty period based on gifts that you've made, but you have to have less than $2,000 for the penalty period to start running. It's a little bit complicated, but the basic idea is that if you make gifts, you can be in trouble Medicaid-wise. You don't really need to know the details, but that's the heart of it. So making gifts without guidance from an elder law attorney can create big problems for Medicaid and long-term care. So how do you do long-term care planning? If you come to an elder law attorney, we often can put together a long-term care plan that saves a significant part of your assets. It's best if you come early when you realize that a loved one is going to need long-term care, but later is better than never. If somebody is already in a nursing home and they have assets to save, if they've already spent all their money down, there's not much that could be done. But if they have assets that could be that are there to save, it's worth a phone call, because there very well may be techniques that could be used to save assets that otherwise would have to be spent on long-term care costs. As for what those techniques are, they vary heavily depending on the situation. They may involve guided transfers. So it may involve putting your house in your kid's name, but it really depends on the situation, and it may involve a mortgage or something else in addition to that. It may involve exempt purchases. It may involve Medicaid qualified annuities, which is different from a regular annuity. It may involve setting up a trust that we talked about earlier. There's a lot of different techniques, and to do it right, you have to have a plan that's custom tailored to your situation, because everybody's situation is different. You need a plan that's customized to your situation. And with each plan, different amounts can be saved. It might be very little, it might be half, or it might be almost all of your assets. It totally depends on the situation. One other note that's very important: if somebody is going into a nursing home or assisted living facility, and they might want or need Medicaid in the future, it's a good idea to have an elder law attorney review the facility's admissions contract And that's because some facilities have admissions contracts that limit your ability to do Medicaid planning or obtain Medicaid. And in addition to that, sometimes the contract can make other family members responsible for the resident's nursing home bills. If you sign as a responsible party, sometimes you can be getting liability, and a lawyer can help you understand those issues and negotiate them with the facility and potentially resolve them.
What's the requirement for income? Say my social security is 2,000 a month.
Yeah. So it changes every year. As of 2017, it is 2205. You have to have less than $2,205 in gross income, so that includes your Medicare premium and all that stuff. If you have more than that, there's a way around it called a qualified income trust. Your income isn't really an impediment to getting Medicaid because of the qualified income trust. So you don't have to worry about the income so much, just the assets. So there's a lot of other aspects to elder law: Medicaid applications, Social Security work, protecting people from financial abuse or elder abuse. But that's the heart of it, long-term care planning. That's usually what the service that people need help with. And the takeaways that I want to leave you with from this presentation are that everybody should have an estate plan, custom drafted by a lawyer, but especially seniors and people with health concerns should have an estate plan. And if a loved one may need long-term care, it's worth speaking with an elder law attorney about Medicaid planning, because you may be able to save significant assets that you otherwise would have to spend on long-term care. And one other thing to note, because this just came up yesterday, a lot of times when people go into a nursing home, the nursing home refers them to a company that are called Medicaid assisters or Medicaid advisors that help you apply for Medicaid. And a lot of times there's not an attorney involved in that. There have been a number of cases in New Jersey where people have gotten advice that wasn't in their interest from that. So, this is going to sound totally self-serving and totally like protectionism, but I really believe it. It's worth talking to an attorney about this stuff. The Medicaid rules are very complex. So that's what I have to say. I'd be happy to take a couple questions. Yeah. So it totally depends on the situation. And the next question I'm sure I'm going to get is, how much does it cost to do an estate plan? So an estate plan could be, I would say low to mid 4 figures would be a safe bet. So somewhere between 1,000 and 5,000. If it's really simple, it could be a little less than that. If it's really complicated, it could be a little more than that. For a long-term care plan or a Medicaid plan, I'd say it's in the mid to high 4 figures. It's a lot of work. You have to go through the 5 years of records. You have to, analyze a person's whole financial life and medical life, essentially, to put it together. So I would say estimate between 5,000 and 8,000. It's a lot, but you're going to spend that money on a nursing home anyway. Yeah. The best time to start planning for Medicaid is when it's first evident that there's going to be a need for long-term care. When somebody first starts showing signs of dementia, right after somebody has a stroke, et cetera. If you don't have any reason to think that you're going to need long-term care, it probably doesn't make sense to start planning now, because all Medicaid planning involves giving up control of your assets to one extent or another, and most people don't want to do that if they don't have to. But if there's some sign that you're going to need long-term care in the future, it's a really good idea to start now. If somebody's already in a nursing home, it's better late than never. I think we had another. Oh, and I'm sorry. The question was, what's the best time to start planning? Yeah.
Yes, we have a will right now, but we were thinking of looking for a living trust.
Mhm.
Since, we have few private property, and we want to make sure that, God forbid that something happens to both of us. Right now, we have, whatever is ours, if I die, it goes to him, or the other way around. But what is the difference between a will and a living trust?
So the question is, what's the difference between a will and a living trust? As I said at the start, I think that most people don't need a living trust, in New Jersey at least. I think that a will is fine for most people. A living trust is an alternate estate planning vehicle. A trust is a different type of legal arrangement. A living trust has certain advantages and disadvantages, but the bottom line is that almost anything you could do with a living trust, you could also do with a will in New Jersey. So for most people, I don't think it's necessary. For some people, it is a good idea to have a trust. I don't really have time, unfortunately, to go into the details.
But, like you said, God forbid one of us was into a nursing home, they're going to attack the house, and then whatever house,
Well,
next to that.
unless it's designed with Medicaid in mind, a living trust is not going to offer you any more protection from Medicaid costs than a will is. Just a generic estate planning trust is not going to, and in fact, it can make things worse for Medicaid. So unless you're planning to do Medicaid planning, a living trust isn't going to help you, unfortunately. Any other questions? Yeah. Oh boy, that's a mess and a half. That's something that that I can talk to you about after the program if you want. It's not something I can answer in 30 seconds. Yeah. So the question is, would a residential trust save the inheritor the taxes? And the answer is no. In most cases, estate and inheritance taxes, if that's what you're referring to. With income tax, maybe there's some things that could be done with income tax. But when a person dies, they get a stepped up basis anyway, so there usually is no income tax. For estate tax, it applies whether it's in a trust or a will. There's some really high-flying things that you can do with trust to save estate taxes, but it's not appropriate for most people unless you have millions and millions of dollars. Most tax advantages that you get with a trust, you can also get with a will, unless you're really talking about people with $10 million or whatever. If you have that, great. We'd be happy to help you, but for most people, that's not the case.
Mark, can I make a comment, please? I wanted to address you, ma'am, about sharing information. I was a caregiver of my father, and one thing that I found very helpful was to keep on the refrigerator with loved ones a document with all medications, all important procedures, so when there's an emergent situation, you hand that to the paramedics, you hand that to the people in the hospital, because as Mark said, the communication between hospital and patient sometimes isn't there. The family may have gone home, there may or may not be a healthcare directive in place. But as a practical matter, this was something my family did, and every hospital we dealt with said it was fantastic, because in that moment, you don't have to remember the medications. The only problem is you have to be computer savvy and kind of keep that document up to date. And I personally would carry that with me at all times. So if I had to meet my father at the hospital, it was on my person. So you leave it in the refrigerator, you keep it with yourself, spouse, family members, children, and at such and such date, this procedure at this hospital, and that would have perhaps informed the doctors. They put it right on the chart, actually. Well, I just think it's a quick and dirty. You have an emergent situation, and all the medications were there with proper doses, and then the laundry list of procedures and where they happened, so that in that moment, it's hard to remember all those things. So if you have it, say, look, here's the document, and this worked very well for my family.
One other thing that people do sometimes is put documents on a USB key. So they have these little flash drives these days. You can get a keychain that's a flash drive. Like that. That's a flash drive. They come even smaller than that. And you can just plug it into a computer and pull up all the documents there. So that's something that some people do. Unfortunately, I have to wrap things up so that my colleagues have time for their presentations. If anybody has any questions, we'll stick around. We'll be happy to talk to you.
Be around
afterwards.
after. We can talk.
So without further ado, Jamie Berger is going to talk about family law and matrimonial law, kind of an overview of what seniors need to know about family law, right?
Absolutely.
And I'll give her my microphone. Take it
Thank
away,
you.
Jamie.
So I don't have to hunch over. Good morning, everybody. Let me know if you're having trouble hearing me. My husband says I talk too loud. So I will, if that's a problem, let me know. Divorce has no age limits, no requirements. It affects everybody. It affects your families. It affects, unfortunately, some of you in this room. And one of the things that, as a practitioner, we deal with is, how the specifics of divorce affect everybody. Every divorce is different in New Jersey. Every divorce is treated, within the confines of the law. you know, the law is the same, but every divorce is factually different. So one of the issues that I wanted to talk about today are sort of, you know, a divorce 101, so to speak, you know, give you the basics and talk about some of the issues that are pertinent to seniors in terms of not only the direct impact on you if you're going through a divorce, but also if you have family members, children, grandchildren who are going through a divorce, and how that could potentially impact you. So there are various types of family law matters in New Jersey. There are FM matters, which are your divorce matters. When you have a couple that is married and they file for divorce, they're assigned what's called an FM docket number. The FM docket number is the thing that you need in order to get into court for your matter to be addressed. And there is an initial filing in New Jersey called the complaint for divorce. There are various grounds for divorce in New Jersey. There are 9 in total. I will tell everybody, because we get a lot of questions, I get a lot of questions as a family law practitioner, you know, my spouse did this, you know, what is that going to impact? You all, unfortunately or fortunately, depending on how you feel, live in a no-fault state. So it doesn't matter from the court's perspective what a spouse may have done to you. Within there are limits to that, but they're generally speaking, if you feel wronged in the marriage, which you typically would if you're deciding to dissolve it, if you feel wronged in the marriage, from the eyes of the law, there is not going to be any kind of financial benefit to you because you feel like you were wronged. If there was any kind of adultery or anything like that, that typically won't impact how your case ultimately resolves. In New Jersey, they adopted several years ago irreconcilable differences as a ground for divorce. That is the one that is most commonly used. What that means is that differences arose between you and your spouse. They've existed for a period of 6 months or more prior to the time that a complaint for divorce is being filed, and that there is no reasonable prospect of reconciliation between you and your spouse. That is what you have to prove in order to proceed under irreconcilable differences in New Jersey.
Is that what they call no-fault divorce?
Yes. And I mean, and when we say it's a no-fault state, it means from the court's eyes, they're not going to make better decisions for you because you can prove that there was fault in the marriage. And again, there are. It's a complex area. There are things that I don't have the time to go into today. There are extreme cruelty counts that you can file, and those can lead to potential what are called Tevis claims, where you can actually sue your spouse for infliction of emotional distress, and you have to prove it, and you have to have experts involved. And those are very complicated legal issues. Typically, when we handle divorces, we're not handling, we handle those issues, but those aren't our typical matters that we're dealing with, you know, most of the time now, because there's not a real clear benefit for a spouse to file for one of the fault-based reasons. We're filing based on irreconcilable differences. Courts really encourage settlement in New Jersey. About 2% of all divorce cases in New Jersey actually go to trial, which is a very small percentage. The reason for that is that courts acknowledge, and family law attorneys acknowledge, that you are better suited to make decisions for yourself in your divorce than a court ever could be. A court has a docket of hundreds of cases at any given time that they're handling. They are never giving the time and attention to your matter that your matter deserves. And so when they are called upon to make those decisions, they're never going to be as well suited as you are to make those decisions that impact you. So when we say that courts really encourage settlement, there are court-mandated settlement processes that are baked into the divorce process. So when we file a complaint for divorce, the first thing that the court will do is they'll set us up for what's called a case management conference. And it's really just an opportunity for a court to manage your case. They see what the issues are, we tell them what the issues are, and they will then put you on a particular track based on what those issues are. So if financial issues are the only concern, they'll put you on one track. If custody issues are a concern, they'll put you on a different track. So it really depends on what those specifics of your case are. And then the court will then put you through a set of paces where they make you try to resolve your case. There's something called an early settlement panel. I'm a panelist in Morristown. I panel cases as well as take my own cases to panel. It's an opportunity where you sit before practitioners who have been practicing only family law, and we devote our time to the court to try to push settlement so that people don't have to ultimately try their case, which is a very costly proposition in New Jersey and a very lengthy proposition in New Jersey. The gold standard is that courts want to see a case from complaint to resolution, either by settlement or trial in 1 year. I will tell you as a practitioner, it does not happen. I have trials that I've been waiting 3 years on in Morris County with no date in sight. So if a case can resolve, it should resolve, because you do not want to spend your time and your emotional energy pursuing a matter that you will feel never ends. So there are other settlement processes. There's what we call economic mediation, where you actually get to leave the courthouse and you go to a mediator's office, and they will attempt to resolve the financial issues with you, and that mediator will give you 2 free hours of their time, which is lovely, to try to settle your case. And then there is what we call the court's last-ditch effort, where they pull us back in for an intensive settlement conference, and I kid you not, they lock us in the courthouse all day. They tell you you can't leave, and sometimes they do it for multiple days in a row, but they are really trying to force you to settle your case. And I will say, you know, in most instances, given the statistics, it is very successful. One of the things, the other thing that you can do, you know, rather than filing a complaint or in conjunction with filing a complaint, is you can elect to go to private mediation. Private mediation, or collaborative law are sects of family law that we call alternative dispute resolution. And what they provide you with is an opportunity to settle your matter outside of court. I am a qualified mediator in New Jersey, as is my partner. We mediate a lot of cases because we see the benefit of mediation for our clients. I mediate a lot of the cases that I have where I'm representing one party, and I also do a lot of mediations because people don't want to be in court. They don't want to be part of a backlog. It's a more humane way to resolve a divorce. You know, generally, if you can sit across the table from somebody and come to a resolution, you're going to walk out of there a happier, more whole person than if you've been litigating in the court system for 3, 4, 5 years. That doesn't seem to garner any good feeling amongst people. So I am all for mediation, and I'm happy to talk to anybody after the fact about the benefits of that process. Again, if you can't resolve your case, you get assigned a trial date, and a trial date in New Jersey, whenever you get it and whenever you're lucky enough to get it, that doesn't mean that you go one day. It means that you have a date that you go to the courthouse, and maybe you get 45 minutes of testimony in, and then they break for lunch, and then they come back and they have an emergent issue that they have to take care of, and then you get another 30 minutes of trial. And then you get assigned a couple more dates, you know, 3, 4 weeks down the road. So it is a very tiring process for my clients. It's not something that I, as a family law practitioner, encourage. I really think that people are more benefited when they can resolve their case in some capacity. And when that happens, you know, sometimes we say we settle cases on the steps of the courthouse, and we really do. We settle the day of trial, waiting in the wings, because the judge, you know, puts us in a holding pattern, and we say, listen, you know, what are the real issues here, and how can we get from point A to point B? So some of the specific areas that impact seniors in terms of the divorce process are retirement benefits. So retirement benefits, 401ks, IRAs, pensions, are things that are subject to equitable distribution. In New Jersey, there's a presumption that equitable distribution is exactly that. It's equitable. It's 50%. And when we say 50%, we mean 50% of the marital portion. So what does that mean? The marital portion of an asset is defined from the date of marriage to the date of complaint. So when you get married, that starts the clock. When you file the complaint, it stops the clock. Sometimes what we do as practitioners, if we're trying to mediate a case or we are trying to settle a case out of court is we'll agree on a cutoff date because we're not actually filing the complaint for divorce. So we are using that as our complaint date because we don't want the clock to keep running in terms of acquiring assets, and otherwise, we would be rushing into court to file a complaint. So when we have retirement assets, IRAs are easy. IRAs we get to just simply roll over typically, depending on the plan, but normally we get to just roll from one IRA to another. 401ks are more complicated. We have to use what's called a qualified domestic relations order, QDRO for short. And what that allows us to do is it allows us to divide retirement accounts that would otherwise be subject to tax implications or penalties, depending on when they're divided. So it allows us to divide those accounts without having to deal with the taxable nature of them, because it would be unfair to a spouse who is receiving the benefit of an asset to have to pay taxes on it if they wouldn't otherwise have to if they were married. So that's how we deal with those types of qualified plans. And the other retirement account or retirement vehicle that we deal with is pension. So depending on where depending on the age of the person who is getting divorced, and obviously the age of the pension holder is what dictates, we will deal with what the marital portion of that account is. It will be divided. If it's in pay status, then we need a QDRO anyway, but the QDRO goes through the pension, and then the pension administrator will divide the account and everybody will get paid separately from it. There's a concept called survivor benefits, though I could talk about that for a lengthy period of time in terms of what it means and what it doesn't mean. In general, what it means is that if a pension allows for survivor benefits, it's going to allow for in a divorce situation, it's going to allow for the recipient of that asset, so not the pension holder's rights, to be protected in the event that the pension holder becomes deceased, either once the QDRO is effectuated or during that process. So survivor benefits are very important. It's very important that your lawyer knows the type of plan you have, receives the documentation on the plan, whether it's a 401k plan or a pension, so that we can see exactly what the benefits are. If in the process of dividing a QDRO, which is not always a quick process, and it often happens after a final judgment of divorce is entered, if in the process of dividing a QDRO there is a death where the pension holder is deceased, as long as the marital settlement agreement is clearly written, generally the plan administrator will honor the terms of the agreement, but you want to be very careful in drafting agreements. And I should go back. There's two ways that a case settles. You either go to trial and a judge makes decisions, or you enter into what's called a marital settlement agreement. The marital settlement agreement is your contract. It is what tells you what your rights are, what your obligations are, and it's very important when we draft those documents, especially when it comes to retirement benefits and division of assets, that we're very clear in the terms of that contract what needs to happen, because sometimes that is what will bind. And I'm sure, as Mark will attest to, you have a will and then you get divorced. Well, you also have an MSA, which says what happens with particular assets. So there may be a dispute there, and you want to make sure, if you have gone through a divorce or you are in the process of going through a divorce, that you're also updating your estate plan, because you don't want to have a will that is naming your spouse as the recipient of all of your assets if you have an agreement that says otherwise.
Yeah, absolutely. And in addition, there are laws in New Jersey. There are a couple of different statutes that say that when somebody gets divorced, certain things are automatically revoked. Bequests to your spouse are revoked. Appointing your spouse as executor or healthcare directive is revoked, which is probably a good thing if you go through a nasty divorce. You might not want your spouse making the decision whether to pull the plug. But that only takes effect if the divorce has been finalized, if a judgment for divorce has been issued.
Right.
If you've already filed a complaint and you're going through a nasty divorce, and you know, you probably don't want your spouse in those roles, even in that case. So it's a good idea to update your estate documents, or if you've never done one before, to make estate documents when you first decide to get divorced.
Well, and that's, I mean, and I'm gonna actually hold questions until the end. I feel like that'll be easier. So if you have any questions, just jot them down. And that's we